But you would agree that it's the role of the jury, not the special counsel, to weigh the facts and to determine guilt?
Ultimately, yes.
Okay. And then one other thing about you relating to your statement, and we'll get into this a little later on, but the toll record subpoenas for members of Congress, we have some very serious concerns about acquiring these toll records, relating to senators and members of the House. I mean, members of the House and the Senate have protections under the Constitution that allows them speech or debate protections. And the toll record subpoenas, in our view, and if we had to litigate it, the House lawyers would take the position that those toll record subpoenas violated the speech or debate protections. And is that something you disagree with?
Yes.
Okay. And we'll get into that a little bit later. We first wrote to you on October 14th, inviting you to testify. And then we worked with the Justice Department and your counsel to make sure you had access to everything you needed to prepare for today. Did that occur? Did you have enough access to the information you need to prepare?
Yes.
Okay, so we asked the Justice Department to make all your files available, to allow you to go to the Justice Department whenever you wanted to, with your lawyers, whoever you wanted to. And I just wanted to confirm that you had the opportunity to review whatever you needed in your files before today.
Yes, we reviewed the files.
Okay.
That's correct.
There might be an issue with classified materials. We don't intend to ask you anything about anything classified. Obviously, if your security clearance is no longer valid, there's an issue on that front. But everything except classified information was supposed to be made available to you, and I just want to confirm that that was the case.
I'm not sure if everything was. For example, the emails of people on my staff. I'm not sure I had access to that, but we did spend, consistent with what you said, time at the Department of Justice, and we had the opportunity to review files.
And that access was made available early, like November 10th, if I'm not mistaken, and I think you guys started reviewing it somewhat shortly thereafter?
That sounds about right.
Okay. You have referenced in your pleadings, I believe, and also in public statements you've made, the famous Robert Jackson speech entitled "The Federal Prosecutor" that he delivered at the second annual conference of the United States Attorneys in 1940. You're familiar with the Robert Jackson speech?
I am, yes.
Okay. And this is widely available on the internet. I didn't make copies for everybody. Everybody can Google it right now as long as your phones are working. And I'm just going to flag some things that Robert Jackson said and just get your reaction to see if you agree with it or not. He says in the second sentence, "The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous." Do you agree with that?
I agree that prosecutors have a lot of discretion, yes.
Jackson stated, "While the prosecutor at his best is one of the most beneficent forces in our society, when he acts from malice or other base motives, he is one of the worst." Do you agree with that?
I do.
On page 4 of his remarks, in the penultimate paragraph, Attorney General Jackson states, "What every prosecutor is practically required to do is to select the cases for prosecution and to select those in which the offense is the most flagrant, the public harm the greatest, and the proof the most certain." Would you agree with that?
Yes.
If a prosecutor is obliged to choose his cases, it follows that he can choose his defendants. Therein is the most dangerous power of the prosecutor, that he will pick people he thinks he should get, rather than pick cases that need to be prosecuted. With the law books filled with a great assortment of crimes, a prosecutor stands a fair chance of finding at least a technical violation of some act on the part of almost anyone. In such a case, it's not a question of discovering the commission of a crime and then looking for the man who committed it. It is a question of picking the man and then searching the law books or putting investigators to work to pin some offenses on him. Do you agree with that?
I do, I think, yes.
Okay. It is here that law enforcement becomes personal, and the real crime becomes that of being unpopular with the predominant or governing group, being attached to the wrong political views, or being personally obnoxious to or in the way of the prosecutor himself. Do you agree that that is a concern?
These are principles, and I agree with these principles.
Okay. In times of fear or hysteria, political, racial, religious, social, and economic groups often, from the best of motives, cry for the scalps of individuals or groups because they do not like their views. Do you agree with that?
Yes.
He concludes by saying the qualities of a good prosecutor are as elusive and as impossible to define as those which mark a gentleman. And those who need to be told would not understand it anyway. A sensitiveness to fair play and sportsmanship is perhaps the best protection against the abuse of power. And the citizen's safety lies in the prosecutor who tempers zeal with human kindness, who seeks truth and not victims, who serves the law and not factional purposes, and who approaches his task with humility. Do you agree with that?
Fully.
And do you think during the pendency of your special counsel work that you tried to live up to those standards?
I do.
Was there ever a prospect after you were appointed special counsel when you thought maybe you would not bring an indictment against President Trump?
Absolutely. When I took this case, I did not know enough about the facts or the law to have a judgment about whether we should proceed in either case, both cases, or neither case. I used my time when I was appointed to get up to speed on the facts and the law. But if the facts and the law did not justify going forward in this case, I would have been perfectly comfortable in doing that, as I have throughout my career in cases involving political figures when I was in public integrity and throughout my career. So I did not have a preconceived outcome in mind when I took this job.
Was there any point where you and your prosecutors that formed your team debated not bringing charges against the president?
Of course. I mean, that is the process of being a prosecutor, is you are analyzing evidence, you're collecting facts, and you're debating whether it's what the facts mean, the inferences to be drawn from the facts, or debating what the law is, and whether you can prove what you think is happening here or not. And so that was a continual process to decide if in fact we could go forward. And that, and again, just to be clear, that is a process that I have undergone in my career personally and with prosecutors I've supervised.
When was the decision made that you believed you needed to move forward with both indictments, both in Florida and D.C.?
Well, so the decision wasn't made at the same time. To the best of my recollection, in both cases, the final decision was shortly before we sought indictment.
Okay. In June of 2023, you had a meeting with the Attorney General to present a prosecution memo and basically asking for his blessing to bring the indictments. Is that correct?
We did have a meeting, and I think it was around that time. I didn't think about it as his blessing. I was presenting what I intended to do, and he had the ability to countermand that if he wanted to.
Okay. But certainly, you couldn't bring an indictment without his authorization.
He could block me from doing that. That's correct.
Okay. And during that June 2023 meeting with the Attorney General, did you guys discuss both indictments, potential indictments, or just the Florida indictment or just the D.C. indictment?
If it was, I don't have a specific recollection of dates, and so you can check me on public records, but I believe by late June, the classified documents case had already been indicted.
Okay.
So again, this is my recollection, but that would have been, a discussion in late June would have likely been about just the elections case,
Okay.
if it was about an indictment.
Okay. And the Attorney General in the June meeting, it's been reported that he expressed some reservations about the DC case. Is that correct?
I had several meetings with the Attorney General about both cases, and in those meetings, we regularly discussed legal issues, factual issues, things of that nature. Never in those meetings did he tell me I couldn't or shouldn't go forward or should go forward. It was more talking through with another experienced lawyer the legal issues present in the cases, as well as if I was going to go forward, how to best frame those.
Okay. Coming out of the June meeting, it's been reported that he asked you to spend some time with the Solicitor General to review the DC case. Is that correct?
Again, I don't recall specific conversations. What I can share with you is we consulted with the Solicitor General regularly during my time as Special Counsel. That was a choice I made. We wanted to make sure not only that we got the facts right, but that we got the law right as well. And so I would be surprised if the first time I consulted with the Solicitor General would have been in late June. That would surprise me.
Okay. But you did have a one-on-one meeting with the Solicitor General in person?
I've met the Solicitor General in person. My recollection is most often it would be members of my senior staff speaking with her staff about these legal issues. I did have conversations with her as well, but the majority of that was her staff and my staff speaking about things.
Okay. And as it's been reported, the Attorney General at the time was concerned that the proposed indictment or the proposed prosecution plan, may have relied too heavily on statements that the president had made and infringed on his free speech if you were going to prosecute him for it. Is that fair?
As I sit here right now, I can't remember specific conversations. I do remember that we knew that a sort of First Amendment defense would be part of the case. And I think when I mentioned to you earlier about how to frame the case, we wanted to make clear that this was not about trying to interfere with anyone's First Amendment rights, that this was a fraud. And as you know, under Supreme Court precedent, fraud is not protected by the First Amendment. And so in my mind, it was important to make that clear in the indictment. And that's why when we litigated this issue before the district court, we prevailed.
But the president's statements that he believed the election was rife with fraud, those certainly are statements that are protected by the First Amendment, correct?
Absolutely not if they are made to target a lawful government function and they are made with knowing falsity. No, they're not. That was my point about fraud not being protected by the First Amendment.
I mean, there's a long list of disputed elections. I mean, the election of 1800, 1960, year 2000, where candidates believe they were wronged by because they lost. And there's a long history of candidates speaking out about they believe there's been fraud, there's been other problems with the integrity of the election process. And I think you would agree that those types of statements are sort of at the core of the First Amendment rights of a presidential candidate, right?
There is no historical analog for what President Trump did in this case. As we said in the indictment, he was free to say that he thought he won the election. He was even free to say falsely that he won the election. But what he was not free to do was violate federal law and use knowingly false statements about election fraud to target a lawful government function. That he was not allowed to do. And that differentiates this case from any past history.
A lot of these statements, though, people come into the Oval Office. I mean, the president isn't conducting his own due diligence. He is receiving people in his office that are telling him these things, whether it be Rudy Giuliani, whether it be John Eastman, whether it be Jeffrey Clark, whether it be Sidney Powell. And, you know, for the most part, he is just receiving this information and, you know, his statements are almost just regurgitating what these people have told him. I mean, isn't that the case?
No, and in fact, one of the strengths of our case and why we felt we had such strong proof is our witnesses were not going to be political enemies of the president. They were going to be political allies. We had numerous witnesses who would say, I voted for President Trump. I campaigned for President Trump. I wanted him to win. The Speaker of the House in Arizona, the Speaker of the House in Michigan. We had an elector in Pennsylvania who is a former congressman who is going to be an elector for President Trump, who said that what they were trying to do was an attempt to overthrow the government and illegal. Our case was built on, frankly, Republicans who put their allegiance to the country before the party. And so the president got information from people he trusted on other issues. He rejected it whenever it didn't fit him staying in office. And there was a pattern in our case where anytime any information came in that would mean he could no longer be president, he would reject it. And any theory, no matter how far-fetched, no matter how not based in law, that would indicate that he could, he latched onto that. And we were confident that we had very strong proof of that pattern. He also, I would just add, very consciously did not try to reach out to the sort of people who have the most expertise on these issues. He reached out to people who he thought could back him up.
Yeah, but let's be honest. The president